goes to the VEC. However, if your claim closes and there's been a gap in weeks, you should know that there is a specific provision that the VEC has that says in certain, although very limited circumstances, you can make requests not only that your claim is reopened so you can report and claim weeks going forward, but that you may be able, as I mentioned, in very limited circumstances, to make claims also for those weeks going backwards that you missed. And those involve situations where the VEC is giving you bad information or is otherwise at fault, or for whatever reason you are not at fault for the gap. And like I said, that's pretty limited.
Yeah. So another place that claimants can get hung up in this process is when there's an issue on their claim. This is a pretty generic term, and what this means can vary depending. What it appears to mean is that there's something that has happened in the claim where the VEC has either incomplete or inconsistent information, typically. If you said when you applied for unemployment that you were getting severance, and then the VEC sent a form to your employer asking for information about that, and they never returned it, there may be an issue on your claim where the VEC, they know there's something going on here, but they haven't gotten a response yet. And so for whatever reason, your claim is hung up at this point. This is something that you need to respond to in order to move the claim forward. You should get a notice of this somehow, either from a written notice or when you talk to the VEC. For some reason, they'll say, oh, you have an issue on your claim. And you'll need to address this and provide them with the information that they need to go forward. Sometimes this may take some persistence on your part. There's a call line sometimes that you will be directed to call, and at least in the past, maybe it's improved now, but it would be busy for long periods of time. And so, as Marty said, you may want to have a good book with you when you call it. But you need to persist through this and make sure that you clear up the issue on your claim. Otherwise, you may lose benefits, or if enough time passes, your claim may be closed out by the VEC because you haven't gone in and addressed this. While you're doing this, you should also make sure that you are on top of any appeal deadlines that may be happening in the rest of your case. If you've gotten your deputy determination and the time is running to appeal that, you need to take care of that as well. All of these, as Carol said, all of these are different tracks that move along on their own track. And so what's happening on one, you may not necessarily be warned about what's happening on other tracks at the same time. So that's an important issue to keep in mind.
And the third issue we wanted to flag is extended unemployment compensation. As people may have heard, given the current economy, the federal government has stepped in with some additional monies for extensions of unemployment benefits. And generally speaking, those extensions are available to workers who applied for regular unemployment compensation, been found eligible and qualified to receive those benefits, and exhausted their regular unemployment claim. When we say exhausted, for example, going back to that initial monetary determination where it says, for example, $166 available each week for up to 20 weeks. That's for people that have made claims for 20 weeks and had their claims processed and exhausted that total benefit amount in their account. Now, typically, at least so far as we know, it's generally supposed to be a seamless system where if you have applied for unemployment, gone through it, and you're getting close to exhausting it, or you're otherwise potentially eligible for extended unemployment compensation, the VEC typically sends applications to folks or otherwise lets them know about availability. But that doesn't always happen, and don't assume that it always happens, such that if, well, first off, if you receive the application, don't automatically assume you're going to qualify, but more importantly, if you don't receive information, don't automatically assume that exhausting your regular unemployment claim is the end of the line. One scenario in which they may not tell people, and we don't know that this is across the board, but in some cases, people that have had sufficient wages, so they have the monetary eligibility, and are able and available to work, so they have sort of the weekly job eligibility, but for whom the employer is either disputing the work-related misconduct issue or the voluntary quit issue. For claimants that have been denied either by the deputy or even by the appeals examiner and are still appealing that, when the VEC looks at those cases, they'll say, well, this person isn't qualified for regular unemployment compensation because thus far they've been found disqualified. If down the line you're able to get that overturned so that, like I said, the appeals examiner or the special examiner or the circuit court says, no, that's wrong, this person is qualified for unemployment compensation. During the period of time where the VEC has found that you've been disqualified for unemployment compensation, even if you get that overturned down the line, in the meantime, while they're sending out information about extended unemployment benefits, it's possible that they've missed notifying you when you might otherwise be eligible. So the question is what to do about that. And as with other types of, for example, issues on the claim, the point is to follow up proactively as soon as possible with the VEC, either through the telephone or if it's easier for you to go to the in-person office or you can't get through on the telephone, be sure to inquire about that as soon as possible. Request an application if you think you're eligible. And as with any other issues involving your unemployment claim, if you're denied and you disagree with the denial or you think it's based on either incorrect facts or a misapplication of law, be sure to file an appeal as soon as possible. Most issues associated with unemployment have very strict 30-day deadlines, beyond which typically if you haven't appealed within 30 days, you will have lost your right to appeal. And there's limited exceptions to that, but they're very limited. So the general rule is to get on things as soon as possible. And that ends our segment. And I think now we wanted to sort of leave a portion of time, if I'm not mistaken, available for people asking questions that might have.